it's almost impossible to sue the credit reporting agencies because they are so well insulated. So just as a practice point, if you are going to utilize the FCRA, I definitely recommend going after the information furnisher instead of the CRA. So under the FCRA, the Fair Credit Reporting Act, you have a choice to make. You can either go after actual damages, in which instance you would need a credit expert to quantify the amount of credit damages, or you can also get statutory damages ranging from $100 to $1,000, depending upon the defendant's conduct. And then you also have a possibility of punitive damages at the court's discretion. So 3 types of possible damages with the FCRA, and these generally fall into 2 categories. One, you've got the false or inaccurate derogatory cases where the information furnisher is reporting false or derogatory information. And then second, like the case we just went through a minute ago, you've got the impermissible access or impermissible pull cases where a credit furnisher like Home Depot would continually pull your client's credit report for no good reason. This negatively affects their credit in many ways. So we've established what credit damage is. We've gone through the sources of law and a few different types of causes of action. What's the evidence you need? Now, if you start singing that freecreditreport.com song at home, I'm going to reach through my computer and smack you, because the credit reports offered on these free credit services are shit. And I did say that right there. They're shit. They're no good. You cannot use them. You take them into court, they'll laugh you out the door. These are what's known as consumer disclosure reports. These are no good. They contain up to 44% errors by some standards. So consumer disclosure reports available from over 1 million online sources. They're typically a free gift, some sort of product or service. They're shit. Don't use them. They're no good. What you want to get your hands on is a subscriber report. These are the only type that are accepted by subscribers, and there are several types at several different costs. They're available only through 900 authorized dealers. These are what lenders use to determine one's creditworthiness, not freecreditreport.com. This is the type of evidence that you will need in court to proceed on a credit damage claim. So next time you see one of those stupid commercials of that idiot singing a stupid song, just turn the TV off or hit mute. All right, so lastly, I just want to finish up with a few cases which I'll go into a little more detail. And this is really where credit damage is all about. That's why I call this damages for the 21st century. 100 years ago, there was no credit. That's why there was defamation, because that's how people would judge you in your community, your personal reputation. That's how you would get jobs, and if they gave loans back in the day, it was probably on your personal reputation as a person. There were no credit reports. Well, fast forward 100 years to now, and that's the only way you get anything is with credit and your credit report. People don't know you personally. They just look at a 3-digit number, and that's your cost of borrowing. And in today's day and age, with the internet and transactions just taking place rapid fire all over the world, and if you got these home mortgages and car loans, and you got papers and documents, and things are sent everywhere, loans are sold, a lot of these times that people work in these offices, they don't keep track of this. So now there was a case in Southern California recently where a couple got $750,000. So this couple lived in San Clemente. They had their home red tagged because of land instability. So they contacted Wells Fargo to get a loan forbearance on their agreement. Wells Fargo agreed, then transferred the mortgage to Freddie Mac. Freddie Mac, the mortgage holder, charged off the loan with a 0 balance and no negative credit remarks. However, Wells Fargo continued to report negative, false credit information to the credit bureaus that this couple in question, the Fishers, were between 30 to 90 days late on their mortgage payments, even though Wells Fargo didn't even have the loan anymore. Wells Fargo then also begins foreclosure proceedings on the Fishers' home when it has no right to do so. As this goes on for 2 years, the Fishers diligently try to correct the situation. On one hand, Wells Fargo sends them a letter saying everything's being taken care of, we're cleaning up the credit information. Then on the other hand, they continue to report to the credit agencies that the Fishers are in default on this loan, and they continue to create this negative credit information, which just screws their credit. So eventually a jury found in their favor, And the couple received $750,000 in actual and punitive damages. So close to $1 million due to the damage inflicted on their credit by Wells Fargo. And that's a case, I believe, that was brought under the common law of California. So now here's another case out of the Fourth Circuit, and this is brought under the FCRA. This is Saunders versus Branch Bank and Trust Company of Virginia. There, the Fourth Circuit Court of Appeals upheld an award of $80,000 in punitive damages under the FCRA, even though the jury found no basis for any actual damages, which I would surmise was really terrible lawyering. So here's the facts. A plaintiff goes into the car dealership, he trades in his car, and he finances a second car. The dealership paid off his note on the trade-in and financed the second car with the same bank, BB&T. So BB&T apparently misplaces this new information on the new car that the plaintiff Saunders purchases, and Saunders never receives a new payment book. So, he repeatedly tries to pay on the loan. He calls the bank. He says, I've got a loan with you. Let me pay you. The bank will not take his money. They say, we've got no loan. You owe us nothing. DMV records show no lien on his car title. 6 months later, the bank wakes up. BB&T suddenly demands $20,000 in overdue payments, late fees, and other charges, trying to stick him with the bill for their negligence. So, of course, being the stand-up guy that he is, Saunders is willing to meet his loan obligations, but he refused to pay anything until the bank dropped the penalties and late fees because it wasn't his fault that he was late. BB&T would not agree to drop these penalties. Instead, the bank repossessed the car, torpedoed his credit, and refused to acknowledge the dispute about the legitimacy of his debt. So, in the end, the court eventually found for $80,000 in punitive damages, even though there was any actual damages. And that's where I'm almost thinking this is a malpractice claim, because this guy's got some serious damage to his credit reputation. When his credit score goes from 800 to 500, the cost of borrowing just goes up through the roof exponentially. I haven't worked out the numbers exactly, but I think a drop of 100 points can be the difference in $30,000 on a $100,000 loan. So this is major, major, major money that we're talking about. So again, this is credit damage, damage to your client's financial reputation through no fault of their own, done at the hands of third-party companies. And again, this is a special damage evinced by reduced credit capacity, increased out-of-pocket expenses, or loss of credit capacity due to third-party actions that cause negative information to negligently appear on your client's credit report. So again, I'm Jason Castillo, the Director of Legal Education with Attorney Credits. We'd love to hear from you. If you got an idea for a micro-seminar, maybe some courses that we need to host on our website, attorneycredits.com. You can check us out on Facebook. Take a look at us on Twitter. We've got a really great blog going. And of course, you found us on YouTube. So thank you very much. Have a great night. Appreciate you checking out our video.